vigilance, articulateness, and effectiveness, unhedged amending. Power will not endanger the interests of the religious, linguistic, and cultural minorities in the country. Judicial review will only isolate the minorities from the mainstream of the democratic process. The argument of fear is not a valid argument. While construing the Constitution, it should be presumed that power will not be abused. In the absence of explicit mandate, the court should abstain from striking down a constitutional amendment which makes an endeavor to wipe out every tear from every eye. In so doing, the court will not be departing from, but will be upholding the national tradition. 919 to 924 State of Madras V.V. Giro, 1954, S. Kelt 591, Virendra Singh and Aurav D. State of Uttar Pradesh, 1955, 1 SCR 415, State of West Bengal Vir. Subodh Gopal, 954 STR 587, Shes 55, Sayan Singh V. State of Rajasthan, 1962. ISTR 933, Sankari Prasad Singh Union of India, 1952, SCR 89, DI Laws Act, 1950, SCR 519, State of West Bengal Furiatur. Anwar Ali Sarkar, 1951, SCR 747, 1079 referred to Kesavananda Bharati, Dwivedi, J. 73. The 24th Amendment. Except as regards the assent of the President to the bill, everything else. The 24th Amendment was already there in the unamended Article 368. According English, the amendment is really declaratory in nature. It removes the doubts asked on the amending power by the majority judgment in Golaknath, even assuming that the restrictions imposed by Article 13.2 and inherent and implied limitations were a part of the body of Article 368. These restrictions are now removed by Parliament, for they will fall within the ambit of the word amendment. The phrase notwithstanding anything in this Constitution on the newly added Kalyalta 1 of Article 368 is apt to sweep away all those restrictions. In the result, the amending power is now free of the incubus of Article 13.2 and inherent and implied limitations. Copy 924 to 926, Section 2 of 25th Amendment. As the word compensation found place in the old Article 31.2, this court held that the principles should be relevant to compensation, that is, to the just equivalent of the property acquired. That word is no more there now, in Article 31.2. The notion of the relevancy of the principles of compensation is jettisoned by Section 2. Obviously, where the law fixes the amount, it cannot be questioned in any court on the ground that it is owed adequate, that is, not equal to the value of the property acquired or requisitioned. The legislative choice is conclusive. It would follow that the amount determined by the principles specified in the law is equally unquestionable in courts. It is not permissible to import in the amended Article 31.2 the notions of arbitrary amount or illusory amount or fraudulent amount. Although the amended Article 31.2 will abrogate the right of property, it is constitutional as it falls within the scope of the 24th Amendment, P. 26 to 931, State of West Bengal, v. Mrs. Bella Baneri, 51 SCR 548, Vairavelu VU, Special Deputy Collector Madras, 1965 and ESCR 614, Union, Fakibor, Metal Corporation, 1965, ISCR 627, State of Gujarat Vishanti. Almangalda, 1969 3 SCR 341, RC Cooper Feeder, Union of India 1973 SCR 530 referred to. Section 3 of the 25th Amendment. Under Article 31C, the court still retains power to determine whether the law has relevancy to the distribution of the ownership and control of the material resources of the community and to the operation of the economic system and concentration of wealth and means of production. If the court finds that the law has no such relevancy, its Sound will declare the law void if it offends the provisions of Articles 14, 19, and 31. The second part of Article 31C excludes judicial review on the ground that the law does not give effect to such policy, so the law cannot be challenged on the ground that the means adopted by the law are not sufficient to subserve the common good and prevent common detriment. In other words, the sufficiency of the law's efficacy alone is made non-justiciable. P. 931 to 934J. Assuming that the Parliament may not delegate the constituent power, Article 31C does not authorize the state legislatures and the Parliament as a legislative body to amend any part of the Constitution. The true nature and character of Article 31C is that they arc in partial eclipse as regards laws having relevancy to the principles specified in Article 39B and C. Article 31C is 10 thick nature of a saving clause to Articles 14, 19, and 31. The effect is brought about directly and immediately by the choice of the constituent power expressed in Article 31C itself, and not by the laws which claim its protection. Sign-on 34 to 936. 74 Supreme Court Reports, 1973. Supes Kirhari Shankar Bhaga VTH Stat.